I'm Peter Antonopoulos. Today we're talking about what is a partition action. The modern American family has changed, and with that change, so has how we purchase and hold title to real estate. Now, almost 60% of real estate is owned by more than one unmarried person. From domestic partners to unmarried couples to siblings inheriting real estate from a deceased parent, the complexity of how we hold title to real estate in our society has grown immensely in recent years. When a dispute arises between these unmarried arrangements, whether it be parting ways or a disagreement over management or operations of the property, or otherwise, a divorce action cannot be filed to compel the sale or division of these assets. Instead, we must look to a different remedy for folks that are unmarried. One such remedy, which has become increasingly useful in these changing times, is the partition suit, or the partition action. What is a partition lawsuit? The partition suit traces its origins to Old English common law. Centuries ago in England, feudal system, the majority of landowners held title to their real estate and farmland, with very few permanent buildings or structures. When co-owners of a farm could not come to a mutual agreement solution for dividing the property, they could petition the King's Court for relief. The Chancellor, a type of English judge, then would simply order that the farmland be divided according to each owner's particular interest in the property, a process which came to be known as a partitioning of the property. Thus, if two individuals held equal ownership interests in the farm or the real property, the court would partition the property in half, with one half going to each individual. Likewise, if three individuals co-owned a piece of property in equal interest, each would receive 1/3 of the property in partition. Although the power to partition is very effective when dealing with land itself, the same cannot be said in modern times, because most real property is covered with a house, otherwise known as being improved. So for instance, a house, apartments, and other permanent buildings or structures, which cannot so easily be divided in equal portions. This difference in the times has led to an added element in today's modern day property disputes, the partition by sale. Now the party seeking partition will petition the court to force a sale of the property and then divide the proceeds of that sale according to each owner's interest in the property. So what is a partition by sale? A partition by sale is a particularly effective course of action for the beneficiaries of an estate who cannot agree on what to do with the house they jointly inherit. Often a brother and sister will inherit a family house from their deceased parents. Sister has been living with mom for the last couple of years, caring for her prior to her death. Now mom has passed away, sister wishes to continue living in the family home. However, brother, having a family of his own, wishes to liquidate his portion of the inheritance by selling the house. It's a story as old as the parable of the prodigal son. One beneficiary wants to keep and use the family house exclusively, while the other wishes to reduce his inheritance to cash for use as he sees fit. When applied to this situation, the partition by sale suit is a particularly effective tool for settling the dispute. Under the pressure of partition suit, the siblings have 4 options available to them. 1, sister can buy out brother. 2, brother can buy out sister. 3, brother and sister can agree that sister will continue to live in the house. And 4, the house can be sold to a third party. If brother and sister cannot agree, brother always has the ability to petition the court to force the sale of the house and division of the proceeds. Suits for contribution. In addition to a forced sale, the partition suit permits one party to seek what's called contribution from the other for expenses associated with maintaining the property. For example, if sister had been maintaining the property and paying property taxes and insurance on the property prior to the sale, she can make a claim for contribution from her brother for his portion of these expenses, which would then be deducted from his share of the sale proceeds. Thus, the proceeds can also operate as a balance to equities between the parties. Notably, the contribution amount may exceed the value of the party's interest in the property. For example, assume that the house sold for $100,000 and had an outstanding loan balance of $50,000. After the outstanding loan is satisfied from the proceeds, brother and sister would each be entitled to $25,000. However, sister may allege that brother owes $30,000 in contributions for his portion of the property repairs which she incurred prior to the sale. The $30,000 in contribution would exceed the brother's $25,000 equity and interest. Thus, assessing the following three factors, it's imperative considering a partition by sale to settle a suit for partition disputes. 1. What's the value of the property? 2. What are the debts against the property? And 3. What are the likelihood of any amounts of contribution claimed by the other party with an ownership interest in the property? A party considering a partition action should consult with an attorney to develop a strategy and to set out possible upside as well as downside in pursuing such a remedy. For more information about partition actions or to file a partition action, please contact Antonopoulos Associates at 202-803-5676 or on the web at www.antonlegal.com.